6 times repeat maternity benefit. Maternity Benefit Act 1961, along with its significant amendment in 2017, is a crucial piece of legislation in India that aims to protect the employment rights and health of women during pregnancy, childbirth, and the postnatal period. This Maternity Benefit Act 1961, Sankshiptanga, precisely. So, Maternity Benefit Act 1961 ఏమేమి ఉన్నాయో చెప్పారు. Applicability ఎవరికి? The act applies to establishments employing 10 persons or more in factories, mines, plantations, shops, and other establishments. This includes both the organized and unorganized sectors. గుర్తుపెట్టుకోవాలి. Maternity Benefit Act applies to both organized and unorganized sectors. ఉంది. 10 persons or more ఉంటే చాలు అక్కడ. Eligibility. To be eligible for maternity benefits, a woman must have worked for the employer for at least 80 days in the 12 months immediately preceding the expected date of delivery. Until 12 months before the date of delivery, she should have worked at least 80 days with that particular employer. Key provisions. Maternity leave duration. First ఏంటంటే the amendment increased the duration of paid maternity leave from 12 weeks to 26 weeks for the first 2 children. This can be availed for a period extending up to 8 weeks before the expected date of delivery and the remaining 18 weeks after childbirth. So 8 weeks before delivery, 18 weeks after delivery. Next provision is maternity leave for more than 2 children. So this applies to the first provision, applies to only for up to 2 children. Next provision ఏంటంటే maternity leave for more than 2 children. For women having a third or subsequent child, అంటే third or fourth or fifth అని, the maternity leave remains 12 weeks, up to 6 weeks before and 6 weeks after delivery. ఇది. Someone is having their thing on, yeah. Then maternity leave, a leave for adoption and commissioning mothers. So women who legally adopt a child below the age of 3 months or commissioning mothers, meaning commissioning mothers ante biological mothers who use their egg to create an embryo implanted in another woman. Ante vere women surrogate mother avutundi. The biological mothers are also entitled to 12 weeks of maternity leave from the date the child is handed over. So 12 weeks of maternity leave from the date the child is handed over. Then the fourth provision is work from home option. The act includes a provision allowing women to work from home after the maternity leave period if the nature of work permits and there exists a mutual agreement with the employer. So these two conditions, if the work permits and then there is the nature, the employer agrees, then she can go on work from home option post maternity leave period. Crush facility. Section 11A talks about crush facility. Establishments with more than 50 or more employees are mandated. It is mandatory. So 50 or more employees unte to provide a crush facility within a prescribed distance. Women employees are allowed to visit the crush up to 4 times a day, including rest intervals. So rest intervals the kalpukoni 4 times a day they can visit up the crush. Then mandatory disclosure to employees. Employers are required to inform women employees about the maternity benefits available to them at the time of their initial appointment. This is stipulated under Section 19. Section 12 talks about protection against dismissal. Employers cannot dismiss or discharge a women employee during her pregnancy or maternity leave. Then Section 8, medical bonus. A medical bonus is provided if the employer does not offer free prenatal and postnatal care. So free prenatal and postnatal care offer cheyani pakshamlo medical bonus is something that's provided for. Leave for miscarriage or related illnesses. The act also provides for paid leave for a period of 6 weeks in case of miscarriage or medical termination of pregnancy. For illness arising out of pregnancy, someone has to keep their phone on, the thing on mute because there's a lot of issues. So the act also provides for paid leave for a period of 6 weeks in case of miscarriage or medical termination of pregnancy. For illness arising out of pregnancy, delivery, premature birth, or miscarriage, women are entitled to a paid leave for a period as prescribed by the medical professional. So, whatever the medical professional prescribes, the women are entitled to that. This is for leave for miscarriage or related illness. So, these are the key provisions of the Act. Now, what is the importance of the Act? The Act is meant to protect women's employment. The primary importance of the Act lies in safeguarding the employment of women during a crucial phase of their lives. It ensures that they do not have to choose between their careers and motherhood. Second thing is ensuring maternal and child health. By providing for paid leave, the Act enables women to take advantage and adequate rest before and after childbirth, which is essential for her health and well being of the child. The extended leave period, especially after the 2017 amendment, aligns with the recommendations for exclusive breastfeeding and early childcare. The third important of the act is promoting gender equality. The act is a significant step towards gender equality in the workplace. It acknowledges the unique needs of women employees and creates a more supportive work environment. By mandating creche facilities and work from home options, it helps women balance their professional and personal responsibilities. Next thing is legal empowerment. The Act provides women with a legal right to maternity benefits, empowering them to claim these benefits without fear of losing their jobs. This contributes to their economic security and autonomy. Next thing is social justice. The Act embodies the principles of social justice by ensuring that women are not penalized for their reproductive role. It recognizes the societal contribution of motherhood and places a responsibility on employers to support it. So one is employment protection, second is maternal and child health gurinchi, third general equality, four there is a legal provision where the women can pursue these provisions, and it is also meant for social justice. Sixth important aspect is the amendments, particularly increase in maternity leave, brought India closer to the maternity leave standards recommended by international organizations like the ILO. So the increase in the maternity leave is in sync with what the ILO has prescribed. Addressing evolving family structures, the inclusion of provisions for adoptive and commissioning mothers reflects the changing social landscape and ensures that maternity benefits are not limited to biological mothers. So these are the important aspects that has been brought out by 2017 amendment. Now, we are talking relevant cases. Municipal Corporation of Delhi versus female workers muster roll. The Supreme Court ruled that even casual workers, like those on muster rolls, are entitled to maternity benefits. So, casual workers are also entitled. The court emphasized the maternity benefits are not charity, but a right of women workers under Article 42 of the Constitution, which is the directive principle for securing just and humane work conditions and maternity relief. So this is mentioned in the article in the directive principles of state policy. The court held that denying maternity benefits based on the nature of employment, permanent or temporary, is unconstitutional. So in Municipal Corporation of Delhi versus female workers, these three key points have been highlighted. The key point is the Act extends protection to women regardless of the nature of employment, ensuring dignity and health during maternity. Nature of employment అంటే ఈవెన్ క్యాజువల్ వర్కర్స్ కూడా ఇది వర్తిస్తుంది అని. షా వర్సెస్ ప్రిసైడింగ్ ఆఫీసర్ లేబర్ కోర్ట్ కోయంబత్తూర్. The court held that maternity leave and benefits are enforceable rights even if the employment contract is silent about it. So even if the contract doesn't stipulate this, this by de facto applies. The court held that maternity leave and benefits are enforceable rights. The court said that maternity benefits flow directly from the statute and not from any contract of service. Key point: right to maternity benefit is statutory and cannot be waived or denied even if absent from appointment letters or agreements. Is the Maternity Benefit Act 1961. Any questions, suggestions, additions, improvements?
Yeah, the two cases are the landmark cases, madam. I think last time also we discussed. where they
Correct.
quote about the muster role, because the Supreme Court also had to justify kada, why temporary workers also. So Supreme Court went to Article 42 of the Constitution and said it is humane conditions ఉండాలి కదా, జస్ట్ అండ్ హ్యూమన్ కండిషన్స్ని కోట్ చేసి ది జడ్జ్మెంట్ ఎందుకు వ్యాలిడో కూడా వాళ్ళు చెప్తారు కదా. సో అందుకని
Correct.
ఆర్టికల్ 42 కోట్ చేశారు అనమాట. సో ఇది చాలా ఆర్గ్యుమెంట్స్లో ఎవ్రీవేర్ ద యూజ్. అండ్ ద సెకండ్ వన్ ఇస్ ఆల్సో a landmark judgment by Supreme Court, where the court held that the maternity leave and benefits are enforceable rights. So మీరు ఎంప్లాయీ కాంట్రాక్ట్లో I will waive my maternity leave అని రాసిన it is not valid.
Correct.
నాకు డబ్బులు అక్కర్లేదు అని రాన్ చేసుకుంటారు అనమాట. రాన్ చేసుకున్నా it is not valid. They can still claim
Correct.
for
They
it.
can still go to court of law.
Yeah. So these are two important sections where they use in arguments.
Yes.
Okay, madam.
Shall I move forward?
Yeah.
I'll read one more thing. Yeah. Next thing is, we also read this in the long question. Gratuity. So this is about the Payment of Gratuity Act, repeated 5 times. Payment of Gratuity Act 1972 is a crucial social piece of social security legislation in India, ensuring gratuity payments to employees in various establishments like factories, mines, plantations, ports, railway companies, shops, and other specified establishments. Now, what are the salient provisions of the Act? First, what does the Act apply to? The Act applies to establishments that employ 10 or more persons on any day in the preceding 12 months. ఒక్క రోజు కూడా preceding 12 months లో 10 or more persons ఉంటే the Act applies. Once covered, an establishment remains under the Act's purview even if the employee count later drops below 10. So that is the important stipulation. Eligibility for gratuity. An employee becomes eligible for gratuity after completing not less than 5 years of continuous service. This gratuity is payable upon termination of employment due to superannuation, retirement, resignation, death, or disablement caused by accident or disease. The 5-year continuous service condition is waived in case of death or disablement. ఈ రెండు conditions లో 5-year condition is waived. This is eligibility. How is it calculated? Gratuity is calculated based on the employee's last drawn salary and the number of completed years of service. The formula is gratuity is equal to 2615 times last drawn salary times number of completed
It's 15
years
by
of
26,
service.
madam. Hello.
అదే
Sorry.
కదా.
అది కింద కరెక్ట్ వచ్చింది, బట్ పైన 15 by 26.
Okay. Yeah, 26 days కదా. 26 days
15 by
that we
26.
work in a month. Correct.
అంటే ఏమైందంటే 15/30 చేస్తే 0.5 వస్తుంది కదా, బట్ వాళ్ళు మళ్ళీ కేసు వేసి దాన్ని ఏం చేశారంటే 30 days ఎలా చేస్తారు, సెలవులు ఉంటాయి కదా అంటే 15/26 చేశారు. సో అప్పుడు 0.557 అవుతుంది.
Sundays తీసేస్తారు.
సో ఏమవుతుందంటే మీకు 0.557 వస్తుంది, కొంచెం ఎక్కువ వస్తుంది 0.5 కన్నా.
అదే కరెక్టే.
దానికోసం ఫైట్ చేశారు.
But that would amount to a lot when it takes
multiplied by last drawn number of years, it will amount to a lot. Yes.
Yeah. So gratuity is calculated based on employee's last drawn salary and the number of completed years of service. The formula is gratuity is equal to 15/26 and 15 days out of 26 times last drawn salary times the number of years of service. Last drawn salary includes basic pay and DNS allowance. So apparently, I mean, if I understand this right, the last drawn salary in this case does not include retaining allowance. It only includes basic pay and it does not include that.
Code of wages, whatever is the wages definition. That is basic
last
wages plus DNS allowance.
Includes basic pay and DNS allowance. ante ikkada.
DNS allowance.
Easy. For number of completed years of service, number of completed years of service ante entante any service period exceeding 6 months in a year is rounded up to a full year. So 6 months or more is full year. The 15/26 factor represents 15 days wages for every completed year. So every completed year, 15 days wages, assuming 26 working days per month. This is the calculation. Maximum amount of gratuity. As per the 2018 amendment, the maximum gratuity payable under the Act is 20 lakh rupees. So, continuous service. What is continuous service? The Act meticulously defines continuous service, including periods of interruption due to sickness, accident, authorized leave, strike, lockout, or cessation of work, not caused by the employee's fault. If any of these happens not without the employee's fault, it is still considered as a continuous service. For women employees, the period of up to 26 weeks of maternity leave is specifically counted as continuous service. This is very key for calculation. Next, payment of gratuity. What is payment of gratuity? Employers must pay gratuity to eligible employees within 30 days from the date it becomes payable. Delayed payments may incur simple interest as notified by the central government. So this is how the gratuity should be paid within a stipulated time frame or else with interest. Nomination. Employees can nominate a person to receive the gratuity amount in the event of their death. If no nomination exists, the gratuity is paid to the employee's legal heirs. Forfeiture of gratuity. Gratuity can be wholly or partially forfeited if an employee's services are terminated for riotous or disorderly conduct, acts of violence, or any offense, including moral turpitude, committed during employment. If any of these things happen, then the gratuity can be suspended, actually terminated. What are the exemptions apart from the appropriate government possesses the authority to exempt certain establishments or classes of employees if they receive gratuity benefits that are equally or more favorable than those provided by the Act. So what does it say? The appropriate government possesses the
Ma'am, my
authority to
voice break
exempt
out.
certain
Ma'am,
establishments or classes of employees.
ma'am, మీ
Oh
వాయిస్
God,
బ్రేక్ అవుతుంది.
am I able to hear me now?
No,
It's not audible now.
no.
So you want to take over from the hello?
Hello. Yeah, ma'am.
You're
So
able to hear me now? No.
now okay. Yeah.
Okay, take over from there now. You're able to hear
Okay.
me?
Yeah, yeah. From point
Okay.
7.
So,
0.9 exemptions we need to see.
I think
Okay. Okay, ma'am. I'll take over.
Shall I take
Okay.
over from here?
Yeah, Pawan garu,
yeah,
please.
please,
Please, sir.
please,
Okay.
yes.
0.9 exemptions. The appropriate government possesses the authority to exempt certain establishments or classes of employees if they receive gratuity or pensionary benefits that are equally or more favorable than those provided by this Act. అంటే if they are providing some similar benefits which are equal to gratuity and అంటే then those can be exempted. And controlling authority and inspectors, the appropriate government appoints a controlling authority to administer the act and resolve disputes, and inspectors to oversee its implementation. Nothing but the government controls, their appointed inspectors will control whether the industry is properly implementing it or not. Penalties. The Act prescribes penalties for employees who fail to comply with its provisions, particularly regarding timely gratuity payment. Within 30 days, they need to clear the gratuity payment. Otherwise, they need to pay penalties. All those are included here. Protection of gratuity. Gratuity payable under this Act is protected from attachment by any court, decree, or order. These provisions collectively define the scope, eligibility, and operational framework of the Payment of Gratuity Act 1972, aiming to provide financial security to employees upon the termination of their long and dedicated service. So when they retire and when they end their employment is terminated, they need to protect it financially. So this amount is paid for them. Amendments. 1977 amendment. This amendment primarily removed the wage ceiling that previously restricted the Act's applicability. By doing so, it significantly broadened the coverage, making more employees eligible for gratuity benefits irrespective of their salary. It also refined the definition of continuous service. I assume there was earlier some limitations to pay gratuity, and in the payment untene we have to pay gratuity, and so that was removed. 2018 amendment. This crucial amendment increased the maximum gratuity payable from 10 lakhs to 20 lakh, aligning with the economic changes. So earlier it was only 10 lakhs was the gratuity payment, is the maximum gratuity payment. Now that is from 2018 onwards, that is increased to 20 lakh. And whatever the services may be, whatever may be the basic wage and dearness allowance, the maximum cap was up to 10 lakhs only. Now that is increased up to 20 lakh. If somebody is getting more than 20 lakh as per the calculation, like 15 by 26 rule, still they would be eligible to get up to 20 lakhs only. That's 2018 amendment.
There is a caveat to that, sir, which we will discuss in the case.
Okay.
Continue. Yeah.
Yeah. Additionally, it explicitly recognized the 26-week maternity leave period as continuous service, aligning the Act with the Maternity Benefit Act 2017 and ensuring women employees' benefits are not affected by maternity leave. First question covering. Both amendments forfeited the Act, expanding its reach and enhancing financial benefits, reflecting an evolving commitment to employee social security. Relevant cases, BCH Electric Limited versus Pradeep Mehra, 2020 Supreme Court. The Supreme Court affirmed the Payment of Gratuity Act 1972 is a welfare legislation ensuring social security for employees. The court ruled that an employer cannot opt out of statutory obligation to pay gratuity, even if offering a supposedly more favorable private scheme. The Act's statutory protection override any conflicting private contracts, establishing gratuity as a right, not a discretionary bounty. So, with this case, it says even though they have some other feature or some other plan which is better than gratuity, but still gratuity has to be intact, and it's not a discretionary bounty of private firms atla అని కాదు అని చెప్పి this case says.
Sir,
Mettur, yes, sir.
Sir, in case law, there are two aspects. Why we have listed this Supreme Court case is one, yes, మీరు సొంత rules, you cannot put your own rules, and then which will override what the gratuity rules are. The second issue in this case was basically you were quoting that 10 lakhs maximum gratuity payable, sir, in the earlier
Yes.
amendment. So what they did is they went back to that, basically that Pradeep Mehra was supposed to get 18 lakhs as a gratuity as per the calculation. But they said that the maximum gratuity payable was only 10 lakhs. So we will not give you more than 10 lakhs. So he went to the court and he said, I am supposed to get 18 lakhs, but they're giving me 10 lakhs. So in that, the court వాళ్ళు ఇంటర్ప్రిట్ ఏం చేశారంటే బేసికలీ దే షోడ్ ద సెక్షన్ 4 or 5 of this act, gratuity act, and then they said limit ఉంది కాబట్టి మేము ఇవ్వలేదు అని. But the court said that those limits are interpreted for people who are not, for example, మీరు 5 years కంప్లీట్ చేయలేదు అయినా కంపెనీ is giving gratuity. Those who are not part of the program, gratuity ఇచ్చిన వాళ్ళకి 10 lakhs limit. But within the program ఉన్న వాళ్ళకి they have to calculate with the whatever is the formula, and whatever number they get, they have to pay that. So this was a landmark judgment in that interpretation also.
Okay. If somebody, let's assume my service and my basic pay is going, and as per calculation, if it is going beyond 20 lakhs, like 25 lakhs or 30 lakhs, they have to pay as per this case.
Correct. So the reason they did it, sir, for example, there is a CEO coming into the company or a director coming into the company for 2 years, and his salary is like 2 crores or 3 crores. అండ్ వాటికి గ్రాట్యుటీ ఒక 1 crore ఇచ్చి పంపించేస్తున్నారు. బట్ ఆ గ్రాట్యుటీ ఏమవుతుంది, గ్రాట్యుటీ పూల్లోంచి వెళ్ళిపోతుంది. సో వీళ్ళు మిస్యూజ్ చేయకుండా ఏం చేశారంటే అట్లాంటి ఇప్పుడు 5 years కంప్లీట్ చేయని వాళ్ళని మీరు ఇంకా గ్రాట్యుటీలో యాడ్ చేస్తున్నారు కాబట్టి వాళ్ళకి 10 lakhs కన్నా ఎక్కువ ఇవ్వకూడదు అని ఇంటర్ప్రిట్ చేసింది సార్ ఈ కేసులో. Sorry sir, go ahead.
Next case is Mettur Bedsell Limited versus Regional Labour Commissioner, AR 1998, Supreme Court 2050. The Supreme Court emphasized A pro-employment interpretation of continuous service under the Act, it clarified that interruptions like leave without pay, strikes, lockouts, or absence due to sickness, accident, uh, do not break service community for gratuity eligibility. The court underscored that technicalities should not undermine an employee right to gratuity, advocating for a liberal interpretation to fulfill the Act's social welfare objective. And any leaves they have taken, misused, and unpaid leaves. Also, somebody wants to take a break in their service due to any reasons or sickness or any other reason, that should not break the continuous service అని చెప్పి మనం ఏదైతే 5 years అని చెప్పి అన్నామో that should not break it అని this case says.
కరెక్ట్ సార్. ఈ కేసు మనము ఇక్కడ ఎందుకు కోట్ చేసామంటే దిస్ ఈస్ ఆల్సో ఎ ల్యాండ్ మార్క్ కేస్ వేర్ అన్ ఎంప్లాయీ వర్క్ ఫర్ 4 years 8 months and he said I want my gratuity. So he went to the court. This case is called the rule of 240. So what the Supreme Court did is 4 years and 240 days నువ్వు వర్క్ చేస్తే నీకు డబ్బులు ఇస్తాం అబ్బా అన్నారు. So and then he won the case అన్నమాట.
Okay, 4 years after that, if he works for 240 days, then
that is considered as 1 year. So this was a landmark judgment in which the 240 number came, sir. So they quote in various other cases or arguments lo.
Okay.
అంటే దీంట్లో ఏమి కన్సిడరేషన్ తీసుకున్నారు? 240 అంటే ఏమైనా స్ట్రైక్స్, లాకౌట్స్ అవన్నీ అయినాయా?
స్ట్రైక్స్, వాళ్ళు చేసిన స్ట్రైక్స్ అవన్నీ తీసుకున్నారు. సిక్నెస్.
ఓకే.
మీకు యూజ్ అవుద్ది మేడం ఇవన్నీ, మీరు ఎలాగో ఆర్గ్యూ చేస్తారు ఫ్యూచర్ లో.
థాంక్స్ అందుకోసం నేర్చుకుంటున్నా.
మీకోసం నేను ఎక్స్ట్రా కేసులు చదివి చెప్తున్నాను మేడం.
వెరీ గుడ్, థ్యాంక్ యూ సో మచ్, ఐ అప్రిషియేట్ దట్.
ఓకే, సారీ పవన్ గారు చెప్పండి.
No problem. That's a good information actually. Conclusion. The Payment of Gratuity Act 1972 establishes a statutory right to gratuity, recognizing long service and providing essential social security upon employment termination. Its clear provisions regarding eligibility, calculation, maximum limits, nomination, and payment penalties ensure a transparent and enforceable mechanism for employees to claim their gratuity, thereby promoting labor welfare and financial stability post-employment. So these guides, this says we have a clear-cut guidelines to pay who is eligible for gratuity, what are the exemptions, and how they can be paid, and all the clear-cut instructions are there under this gratuity. So I'll move on to the next question. Anything?
One last addition to this, అంటే ఇది ఇంపార్టెంట్ క్వశ్చన్ కదా సార్. సో బేసికలీ లాస్ట్ టైం వెన్ వీఆర్ రీడింగ్ అబౌట్ గ్రాట్యుటీ, మేడం సెడ్ గ్రాట్యుటీ డెఫినేషన్ చెప్పలేదు మీరు, అసలు ఎక్కడో చోట రాయాలి మీరు, అది ఇంపార్టెంట్ అన్నారు నిర్మలా మేడం. విచ్ ఇస్ ట్రూ. గ్రాట్యుటీ అన్నప్పుడు వాట్ యూ సే ఇస్ గ్రాట్యుటీ ఇస్ ఎ లంసమ్ పేమెంట్ గివెన్ by an employer to an employee rewarding a long term service. Okay. సో దానికి ఇంకా ఈ లాంగ్ టర్మ్ సర్వీస్ అంటే ఏంటి, మినిమం పీరియడ్ అంటే ఏంటి, దట్ వీ విల్ డిఫైన్ యాజ్ పర్ ద పేమెంట్ ఆఫ్ గ్రాట్యుటీ యాక్ట్ 1972. బట్ బ్రాడ్గా ఏంటంటే 1972 పేమెంట్ ఆఫ్ గ్రాట్యుటీ యాక్ట్ చెప్పే ముందు లంసమ్ పేమెంట్ అని గుర్తుపెట్టుకోండి.
ఇక్కడ కన్క్లూజన్ లో ఫస్ట్ సెంటెన్స్ కన్క్లూజన్ లో ఫస్ట్ సెంటెన్స్ ఇట్ సెల్ఫ్ సమ్మరైజెస్ వాట్ యు సెడ్.
యా,
దట్స్ రైట్.
సో కామన్ కేసెస్ వస్తాయి లేబర్ లో మీరు వెళ్ళినప్పుడు. ఒకటి ఏంటంటే వాడు 10 lakhs లిమిట్ అంటున్నారు సార్, నాకు ఎక్కువ డబ్బులు ఇవ్వట్లేదు. సెకండ్ 5 year లిమిటేషన్ ఉందంటున్నారు సార్. ఈ రెండు కేసులతో ఓవర్కమ్ అవ్వచ్చు.
PCH is for long term, I mean beyond 10 lakhs, and Mettur Bayodcell is for continuous service.
Yeah. PCH is also for I made my own loss, I am from America, నేను గ్రాట్యుటీ ఇంతే ఇస్తాను అంటే దోబ. సో 2 things సార్ అక్కడ.
That's a good addition actually. Next, question 3, full bench formula of bonus. This is repeated 5 times. The full bench formula is a significant concept in Indian labor law, particularly concerning the calculation of bonus payable to employees. It was developed by full bench of Labor Appellate Tribunal in the landmark cases Mill Owners Association of Bombay versus Rashtriya Mill Mazdoor Sangh Bombay in 1950. This formula aimed to provide a structured, equitable method for determining the available surplus of profits from which bonus could be paid to workers. So when they are paying bonus every year, how they need to pay, and that formulas, all these are arrived from this particular case, Mill Owners Association of Bombay versus Rashtriya Mill Mazdoor Sangh. This is related to this particular case only, where they have defined full bench formula. Key components of the full bench formula. The formula outlined a process for calculating the available surplus by deducting certain prior charges from the gross profits of the company. These prior charges typically include statutory depreciation, deductions for the depreciation of assets as per the Income Tax Act, income tax payment of income tax at the prevailing rates, return on paid capital, a reasonable return on the capital originally set at 6% on the capital invested by the shareholders. It's nothing but whatever the company has invested initially, 1 lakh or 10 lakh or 1 crore, like that they need to pay interest on it. A return on reserves used as working capital, a low rate of return on the reserves utilized for the company operations, and a rehabilitation reserve, an amount set aside for the future replacement and modernization of plant and machinery. After deducting these prior charges from the gross profit, the remaining amount was considered the available surplus. A portion of the surplus, as determined by industrial adjudication, would then be allowed as a bonus to the employees. So this says uh, once the company earns some amount of profit, so it allows some deductions, which includes income tax, okay, statutory depreciations, and return on paid up capital, okay, whatever the interest, like 6% interest on share capital, and return on reserves used earlier, and the rehabilitation reserve if, for machinery accreditation, machinery service దానికోసం కొంత అమౌంట్ సెపరేట్ చేసి then the remaining amount would be calculated for bonus payment. So significance of the full bench formula: standardization. Before this formula, bonus payments were often ad hoc and led to frequent industrial disputes. The full bench formula provided a more standardized and rational approach to bonus calculation. So before this, వాళ్ళ ఇష్టం ఉన్నట్టుగా వాళ్ళు క్యాలిక్యులేట్ చేసి దే యూజ్ దేర్ ఓన్ డిడక్షన్స్ కైండ్ ఆఫ్ థింగ్. నౌ ఇట్ హాస్ మేడ్ స్టాచ్యుటరీ వాట్ దే నీడ్ టు డిడక్ట్, వాట్ దే కెనాట్ డిడక్ట్ అన్నది. సో దట్ స్టాండర్డైజేషన్ ఈస్ ఇంప్లిమెంటెడ్. Profit sharing. It established the principle that workers have a right to share in the profits the company as a reward for their contribution to its earnings. Whatever company has earned, they need to share it with the employees also. So balancing interest, the formula attempted to balance the interest of both employees by ensuring deductions for essential financial obligation and employees by providing a share in the surplus profits. Limitations, complexity. The formula could be complex to apply, requiring detailed financial data and calculation. Rigidity over time, concerns arose about rigidity of some of its components, such as fixed rate of return on capital, which might not always reflect the actual income, actual economic conditions. Rehabilitation reserve, the determination of justifiable rehabilitation reserve often became a point of contention. So the limitations are the complexity and I mean how they calculate all those things, the formula, those things, and rigidity like paying the interest, etc. Rehabilitation reserve, when they set aside more amount or less amount, that is also has to be justifiable. These are the limitations. Bonus concept. The term bonus generally refers to an additional finance compensation paid to an employee over and above their regular wages or salary. It is typically linked to the performance of the employee, the profitability of the organization, or other specific achievements or milestones. This is, we can take as a definition also. Key aspect of bonus concept:
సార్ యాక్చువల్గా
Incentive and
ఇందులో ఫుల్ బెంచ్ గురించి అడిగారు, బట్ ఇక్కడ ఏంటంటే నేను ఐ హావ్ రిటన్ అడిషనల్ నోట్స్ ఆన్ వాట్ బోనస్ ఇస్
bonus.
ఆల్సో.
Right.
యాక్చువల్లీ ఎక్కువ మనం ఫుల్ బెంచ్ ఆఫ్ బోనస్ రాయాలి. సో
Yes.
బేసికలీ బోనస్ కాన్సెప్ట్ కూడా కొంచెం యాడ్ చేశాను ఇందులో.
Yeah.
అడిషనల్
Without bonus concept, full bench
ఫుల్ బెంచ్
formula.
అర్థం కాదు కదా.
Right. Right. Yeah, that is the
Yeah.
main. So
Okay,
key aspects of the bonus concept: incentive and reward. Bonus are often used as incentive to motivate employees, reward good performance, and encouraging productivity and profit sharing. In many cases, bonus is seen as a way for employees to share in the financial success of the company. Gratuity versus right. Historically, bonus was sometimes considered as a gratuitous payment. However, through industry legislation like the Payment of Bonus Act 1965, now subsumed under the Code on Wages 2019, and judicial interpretation, it has evolved into a statutory right for eligible employees. Types of bonus, various types of bonus exist, including performance-based bonuses, profit-sharing bonus, attendance bonus, festival bonus, etc. These are types of bonus, and specifically bonus concept is to have ownership. I mean, for the to win the employee faith, those kind of things. Specifically, bonus concept is introduced. Payment of bonus under Code on Wages 2019. Earlier, it was Payment of Bonus Act 1965. Now it is merged with Payment of Bonus under Code on Wages 2019. The Code on Wages 2019 consolidates and amends the law relating to wages, bonus, and other related matters. It subsumes the Payment of Bonus Act 1965 and contains provision regarding the payment of bonus to employees. Key provisions related to bonus under the Code on Wages 2019. Eligibility: every employee drawing wages up to certain notified amount per month who has worked for at least 30 days in an accounting year is eligible for an annual minimum bonus. The appropriate government will notify the wage ceiling for eligibility. So minimum 30 days they need to work in the company to be eligible for the yearly bonus. Minimum bonus, the annual minimum bonus is payable 8.33% of the wages earned by the employee or rupees 100, whichever is higher, irrespective of whether the employer has any allocable surplus in the previous accounting year. So this is the minimum payment condition, 8.33%. It's nothing but 1 month pay, we can say. 8.33%. It comes to close to 1 month salary.
But the condition ఏంటంటే సార్, the code of wages doesn't specify the bonus, but it is saying if you give, this is the minimum bonus.
Yes.
So difference ఏంటంటే పేమెంట్ ఆఫ్ బోనస్ యాక్ట్ 1965 కంపల్సరీ బోనస్ ఇవ్వాలి. 2019 లో మెన్షన్ చేయలేదు.
మెన్షన్ చేయలేదు. Yeah, that is
బట్
company
మినిమం
bill.
బోనస్ ఈజ్ వాట్ దిస్ ఇస్ వాట్ యూ హావ్ టు గివ్. బోనస్ అంటే ఇంత ఇవ్వాలి.
Yes. So 1 month salary they need to pay minimum.
Correct.
Maximum bonus: if the allocable surplus exceeds the amount of minimum bonus, the employer liable to pay a bonus in proportion to the wages earned, subject to maximum of 20% of the employee's annual wages. So up to 20% they can pay if they have extra surplus from previous years, allocable surplus. So calculation of bonus: for the purpose of calculation of calculating bonus, if the wages of an employee exceed a certain notified limit per month, calculation ceiling, the bonus payable will be calculated as if their wage were the calculation ceiling on the minimum wage, whichever is higher. The appropriate government will notify this calculation ceiling. Okay. If somebody is getting more or less salary, so as per that, how the bonus calculation is. Yeah, allocable surplus: the code outlines the manner in which allocable surplus is to be calculated, generally being a specified percentage, 60% for banking companies and 67% for other non-banking companies of the available surplus. The available surplus is derived from the gross profit after deducting certain statutory deduction. మన ఫస్ట్ పార్ట్ లో చెప్పిన డిడక్షన్స్ అన్ని చేసిన తర్వాత వచ్చేది అవైలబుల్ సర్ప్లస్, like depreciation, direct tax. If the allocable surplus exceeds the maximum bonus limit, means about 20% of wages కంటే ఇంకా ఎక్కువ అయితే the excess can be carried forward for future years. In the future years లో ఎప్పుడైనా if it is less, then they can use this under the set on and set off provision. Set on and set off అని చెప్పి there is a separate topic which we had gone through, right? So as per that, as per section 36 of the code on wages 2019. So future years up to 4 years this can be carried forward. Disqualification for bonus. An employee can be disqualified from receiving bonus if dismissed from service for reasons such as fraud, riotous or violent behavior, theft, misappropriation, or conviction for sexual harassment, etc. Agreement for higher bonus. The code allows for agreement or settlement between employers and employees for the payment of bonus linked to production linked or productivity exceeding the minimum bonus. So relevant cases. So Mill Owners Association, there is only one case because the entire this formula came from this case. Mill Owners Association of Bombay versus Rashtriya Mill Mazdoor Sangh Bombay. The Labour Appellate Tribunal held that while wage demands by workers are legitimate, the fixation of wages must be done on rational basis, balancing both workers' need for a decent livelihood and the industry financial capacity. Be done on
So
financial capacity. The tribunal laid down what came to be known as full bench formula, incorporating three-tier wage structure: minimum wage, fair wage, and living wage, which we have read earlier, with the fair wage serving as the realistic standard for adjudication, the middle one. Exactly. It emphasized the need for need-based minimum wage must be ensured to support a worker's essential living requirements, food, clothing, housing, etc., and that any wage fixation must also consider the profitability of the employer and wage levels in comparable industries. This case provided a structured framework for industrial wage adjudication in India and became a cornerstone for latter legislative and judicial approaches to wage and bonus fixation. Actually, this case comes in multiple questions we can quote when it comes to a bonus and code on wages and full bench formula. All these we can quote this case actually.
yeah, correct, sir.
A key takeaway: rational wage fixation through the full bench formula, shaping the framework for fair industrial remuneration in India. Venu sir, anything do you want to say on this case?
No, I think what you said is correct, sir. Millers Owners Association లోనే full bench formula వచ్చింది. ఈ definitions of minimum wage, fair wage, living wage వచ్చింది. But actually, the original definitions of these three came in that Whitley Commission. Remember Whitley Commission గురించి చదువుకున్నాము.
Yes.
1931 లో వాళ్ళు డిఫైన్ చేశారు, మళ్ళీ వీళ్ళు రీడిఫైన్ చేశారు దాన్ని. అది సార్.
అది I mean pre-independence was that one and post-independence is this case. Okay.
And ఇంకొక స్మాల్ థింగ్ విచ్ ఐ వాంటెడ్ టు క్లారిఫై ఈజ్ బేసికలీ ద క్యాల్కులేషన్ ఆఫ్ బోనస్. సో బేసికలీ ఇక్కడ ఏమంటున్నారంటే క్యాల్కులేషన్ సీలింగ్ ఒకటి ఉంటుంది అంటున్నారు. ఫర్ ఎగ్జాంపుల్ 2 వర్కర్స్ ఉన్నారు సార్, సేమ్ దే ఆర్ డూయింగ్ ద సేమ్ జాబ్. ఓకే, they are like welders, 2 welders, one guy is getting 7,000, another guy is getting 10,000. So how do we calculate bonus for the 2 people? So let's assume what is the minimum wage for a welder. The minimum wage for a welder akkada 5,000 undanukondi. So calculated ceiling and pedtaru anamata. Calculated ceiling will be 8,000. So bonus vachesi 8,000 ga calculate chestaru andarki.
So
it is not
this is like equal pay, equal work, equal pay.
So 10,000 వచ్చేవాడికి క్యాల్కులేటెడ్ సీలింగ్ మీద ఉంటుంది. 7,000 వచ్చేవాడికి 7,000 మీద ఉంటుంది. So whichever is higher.
Okay. So based on their salary only this calculation.
Correct.
Okay.
Correct. ఇప్పుడు మినిమం వేజ్ వాడి శాలరీ అనుకోండి, మినిమం వేజ్ మీద ఉంటుంది. క్యాల్కులేటెడ్ సీలింగ్ కన్నా హై ఉంటే క్యాల్కులేటెడ్ సీలింగ్ మీద ఉంటుంది.
So conclusion is while the full bench formula was foundational principle for bonus calculation before the enactment of the Payment of Bonus Act 1965, the Code on Wages 2019, the latest one, like the 1965 Act moves towards a more statutory and formula based approach. The concept of Available surplus and its calculation, which were central to the full bench formula, are retained in the code. The way it is calculated has evolved. Instead of the linkage of bonus to a fixed return on capital, specific deductions and surplus distribution are now governed by the provisions of the code. The code aims to simplify and rationalize the bonus payment process, ensuring a minimum entitlement for employees while also allowing for profit linked bonus based on the employer's financial performance. The specific thresholds and percentages are subject to notification by the appropriate government. So this full bench formula is has laid down all the how it has to be calculated and how it has to be distributed. All the rules and regulations came under this full bench formula. That's what it says exactly. That's it, sir. When sir, you can take over now. When
Can
sir,
you guys hear
you
me?
want to
Yeah.
add anything and anything here, and you can take over now. Yeah.
Okay, sir. Okay. Clear, sir. Thank you. Thank you very much. So we'll go to the ma'am Munara Nirmala ma'am.
Yes, yes.
Okay, okay, all right. Okay.
Yeah.
So ఈ కేసులో మనం we didn't quote different cases because the entire concept of full bench formula has come from a single case. So only single case గురించే మాట్లాడాము ఈ కేసులో. And that is an important question also, full bench formula.
Yes, sir.
Okay. The next one is wages. So basically, they will say what are the minimum fair and living wages we were just talking about. So what are the concepts of this? And this got repeated 4 times. So basically, the term minimum wage, fair wage, and living wage, మనం already ఒకసారి చదువుకున్నాం దీని గురించి, represent different benchmarks in discussion of workers' compensation. They reflect varying philosophies about the basic entitlements of workers and the responsibilities of employers and the society. So minimum wage under the minimum wage is a legally mandated lowest hourly wage that an employer can pay to the employees covered by the law. It is statutory floor set by the government authorities. Purpose ఏంటంటే the purpose of the minimum wage is to protect workers from exploitation by preventing unduly low wages, provide a basic level of income to keep workers meet their fundamental needs, reduce poverty, income inequality, and meet a basic standard of living and workers' efficiency. Characteristics and are legally enforceable, often adjusted periodically based on inflation and economic conditions, varies significantly across countries, regions, sometimes industries. So limitations in minimum wages may not always be sufficient to cover the actual cost of living and ensure a decent standard of life. The second one is fair wages. Fair wage is a level of pay that is just and equitable for both the employee and the employer. So you have to remember these 2 words, just and equitable, for the exam. Fair wage and just and equitable. It lies between the minimum wage and the living wage. So how do you determine it? Determining a fair wage involves considering several factors. One is workers' productivity and contribution. So whatever the skill, effort, and responsibility involved in a job, prevailing wage rates, the compensation of similar jobs in similar industry across regions, and employees' capacity to pay, the financial health, and the cost of living, the expenses required for basic necessities in that particular area, and the level of national income and its distribution, the place of industry in its national economy. So these are all the factors which are used to determine the fair wages. So characteristics say more than subsistence under minimum wage, but less than a wage that allows for significant comfort. Aims to provide a standard family with food, shelter, clothing, medical, and education for children, often determined through collective bargaining and industrial agreement rather than strict legal mandates. Considers the economic realities of industry and the region. So the third one is living wage. A living wage is a minimum income necessary for a worker to meet their basic needs and afford a decent standard of living in a specific location. So basically, if you want a decent standard of living, so what do you mean by decent standard? It means that it goes beyond mere survival and includes expenses such as housing, food, healthcare, education, and transportation, and provision for unexpected events. So basic survival kakunda, if you add the housing, the rent, if you add the food, medical, education, pillar education, and the transportation and the provision for unexpected events, This is what is the living wage. The goal of living wage is to ensure that full-time work can fit individual and families out of poverty and allow them to live with dignity and participate in society. What are the characteristics? Calculated based on actual cost of living in particular geographic area, typically higher than statutory minimum wage, often advocated by labor and community organizations, not always legally mandated. And significance is it ensures workers meet basic needs, reduce income inequality, enhance employee motivation and retention, and strength local economies. So relationship between the concepts, the minimum wage vests a legal right on the workers. The fair wage aims to just balance between the needs and the capacity of the workers. A living wage focuses on ensuring a decent quality of life by accounting for actual costs of essential needs in a specific area. So ideally, a society would strive to ensure all workers get living wages, with fair wage being a desirable standard above that minimum. But the minimum wage serves as a crucial baseline to protect the most vulnerable workers. The discussion and implementation of this basically from country to country vary outly, and basically it shapes the labor policies and addresses economic inequalities. That's what is the three um, different wages are. Maybe you can quote the Whitley Commission as well as మీకు ఇంకా ఓపిక ఉంటే ఈ కేసు కూడా మీరు ఇందాక చదివిన మిల్లర్స్ అసోసియేషన్ కేసు కూడా రాసేయచ్చు, that they've quoted them in both of these. And relevant cases అంటే they've the same standard PUDR versus Union of India, where they are talking about a minimum wage. These two cases are basically about minimum wage and the fair wage. The first one is minimum wage. Some people have accepted employment ఇస్తారు కాబట్టి below minimum wage accept చేశారు, which the Supreme Court said it is forced labor under Article 23. So there is a non-profit association called PUDR which has put this case against Union of India. And then they said that the minimum wages are non-negotiable, emphasizing dignity and social justice for workers. The second one is standard vacuum refining versus its workmen. The Supreme Court explained the gradation among minimum, fair, and living wages. It held that fair wages must approximate a living wage as industry grows and profits improve, emphasizing a dynamic and progressive interpretation of wage laws. So in this case, chala liberal interpretation of fair wages చేశారు, where the Supreme Court said that since the company is doing extremely well, the fair wages must be approximately equal to the living wages. Okay, emphasizing the dynamic and progressive interpretation of wage laws. అంటే మీరు కంపెనీ బాగానే చేస్తున్నారు కదండి, then why can't you increase your fair wage to being pushing it close to a living wage, is what the judgment was. Okay, so these are the two cases in one was in minimum wages and the other one fair wages. And you can also quote the other one, the Millers Association Whitley Commission కూడా మీరు ఇక్కడ రాసుకోవచ్చు ఓపిక ఉంటే. ఏ రావాలంటే అన్ని రాసేసేయండి. Any questions? Okay, we'll go to the fifth question. 10 అయిపోయింది, we'll finish this. Is it okay with everyone?
No, you said I think the meeting is from 9 to 10:30 కదా కాదా?
Okay, we'll go till 10:30 then. ఓకే మేడం, ఫిఫ్త్ మీరు చదువుతారా? మీరు ఫేమస్ సబ్జెక్ట్, ఫేవరెట్ సబ్జెక్ట్ ఇది మీకు.
యా, అది నెక్స్ట్ కూడా నా ఫేవరెట్ లే కానీ. ఓకే, so employees, if my voice is dropping or it's chopping, please stop me because I don't want all of you to suffer. నా నెట్వర్క్ కొంచెం బాగాలేనట్టుంది, బట్ ఎనీవే ठीक है.
ఓకే,
yeah. Employee State Insurance Act 1948, repeated 4 times. This act is a significant piece of social security legislation in India. It was the first major legislation on social security for workers in independent India and aims to provide certain benefits to employees in case of sickness, maternity, and employment injury, as well as to make provisions for related matters. So what are the key objectives and features of this act? First, integrated social insurance scheme. The Act envisages an integrated, need-based social insurance scheme designed to protect the interests of workers and their dependents in times of need. What are the contingencies that are covered? It provides benefits for various health-related eventualities that workers are generally exposed to, which include sickness, maternity, temporary or permanent disablement, occupational disease, death due to employment injury. So these are the cases which are covered, contingencies which are covered under the Act. Benefits provided to counterbalance the physical or financial distress caused by these contingencies. The Act provides several benefits. So in times of above contingencies, these are the things that the people can claim. What are they? First, medical benefit. Covers medical treatment for the insured person and their family. Sickness benefit provides cash benefits during periods of certified sickness. Maternity benefit offers paid leave to women employees during pregnancy and after childbirth. Disablement benefit provides compensation for temporary or permanent disablement caused by employment injury. So it should be out of and in the course of employment. ఆ రెండు conditions fulfill అవ్వాలి with a notional extension. Anyway, dependents benefit offers financial assistance to the dependents of an insured person who dies due to employment injury or occupational disease. Funeral expenses provides a lump sum payment towards the funeral expenses of a deceased insured person. Rehabilitation allowance for insured persons undergoing vocational rehabilitation after disablement. So these are the benefits that these are the social security measures that are provided in case of the contingencies. What is the applicability? The Act initially applied to factories employing 10 or more employees, but in some states, since labor is a state subject, in some states it is 20 or more employees. Over time, its coverage has been extended by the appropriate governments to other establishments such as shops, hotels, restaurants, cinemas, educational institutions, and more, subject to certain employment thresholds and wage limits. Currently, the wage limit for coverage is 21,000 per month, 25,000 per month with for persons with disabilities. So for non-disabled people, it is 21,000. For disabled people, it is 25,000. What is the funding? The ESI
Is this maximum limit or minimum? This is maximum, right? Maximum fund.
maximum. Yes. Maximum limit. Yeah. Funding. ESI scheme is primarily financed through contributions from both employers and employees. The contribution rates are a percentage of the employee's wages. The funds are managed by the Employees State Insurance Corporation, ESIC. How is it administered? The ESIC is an autonomous body under the Ministry of Labour and Employment, Government of India. It administers the ESI scheme, collects contributions, and provides benefits to the insured persons. The ESIC also establishes and runs hospitals and dispensaries to provide medical benefits. So this is how the fund is administered and how the hospitals are also run. Now, no duplication of benefits. The Act absolves employers of their obligations under the Maternity Benefit Act 1961 and the Workmen's Compensation Act 1923, now called Employees Compensation Act 1923, for employees already covered under ESI scheme, preventing duplication of benefits. So if someone is covered under ESI scheme, that particular employer is not obligated to provide any benefit under Maternity Benefit Act or Workmen's Compensation Act because they're already covered under ESI scheme. So what is the importance of ESI Act 1948, pioneering in social security? It is a landmark legislation for protecting the working class, social protection of working class in India. It has comprehensive coverage, includes, we have seen, right, a lot of benefits, medical, sickness, maternity, disablement, dependence, funeral expenses, rehabilitation events, all these benefits. So there is a comprehensive coverage during times of contingency. Then the third thing is promoting workers' welfare by ensuring medical care and financial assistance during times of need. The Act contributes significantly to the welfare and security of employees and their families. Then it is upholding human dignity by providing social security to protect workers from deprivation, destitution, and social degradation during crisis, thereby upholding human dignity. And it is also facilitating economic development, which means a healthy and secure workforce contributes to higher productivity and overall economic development. So these are the important aspects of ESI as to why this is in place. Any questions?
Ma'am, with this question we have already studied in the long Q2. సో
Correct.
ఇందులో నేను కేసెస్ రాయలేదు. మీరు
అక్కడ చూసుకొచ్చున్నా.
కెన్ యూ రిమెంబర్ ద కేసెస్?
Very good. I don't. Let me see.
ద వన్ ఈస్ ద మస్టర్. ఏం తెలిసిన తెలపోయినా మస్టర్ రోల్ మాత్రం రాసేయండి ప్రతిసారి.
First రాసేయచ్చా?
మస్టర్ రోల్
Super.
మున్సిపల్ కార్పొరేషన్ ఆఫ్ ఢిల్లీ వాడు ఈఎస్ఐ ప్రకారమే ఇవ్వనన్నాడు మెటర్నిటీ బెనిఫిట్, which was quoted in
Correct.
long question 2 also. So the muster role is a very good case. The other case is basically notional extension of work. Chadukunam regional director versus Francis de Costa, which is basically automatically sustained injuries
Correct.
commuting to work. It is not covered unless you are using the vehicle, company vehicle, కంపెనీని వస్తున్నావు అంటే నేను నా పిల్లల్ని డ్రాప్ చేసి మళ్ళీ స్కూల్ నుంచి అక్కడి నుంచి నేను ఆఫీస్ వస్తున్నాను, నాకు అక్కడ యాక్సిడెంట్ అయింది. సో దేర్ ఇస్ లాట్ ఆఫ్ అంబిగ్యూటీ రైట్ ఇన్ హౌ యు ఆర్ రీచింగ్ ద ఆఫీస్. సో నోషనల్ ఎక్స్టెన్షన్ అనేది అక్కడ డిఫైన్ చేశారు. కొన్ని కమ్యూటింగ్ యాక్సిడెంట్స్ స్పెషల్ కేసెస్ అయితేనే తీసుకోవాలి, లేకపోతే అవసరం లేదు.
సో ఈ 2 కేసెస్ ఏంటంటే మున్సిపల్ కార్పొరేషన్ ఆఫ్ ఢిల్లీ వర్సెస్ ఫీమేల్ వర్కర్స్ మస్టర్ రోల్ కేసు, అది ఫేమస్ మస్టర్ రోల్ కేసు కదా, అది ఒకటి. అదర్ థింగ్ ఇస్ రీజనల్ డైరెక్టర్ ఈఎస్ఐ కార్పొరేషన్ వర్సెస్ ఫ్రాన్సిస్ డికోస్టా.
ఇందులోనే మీకు వీక్ వెళ్తే తెలిసిపోద్ది.
అక్కడి నుంచే చూసి చెప్పాను.
ఓకే, మీ ఇండెక్సింగ్ కూడా చేశాను మేడం, మీకు ఈజీగా ఉంటుంది చదువుకోవడానికి. Okay, we'll go to the next one. Sixth
question is about social security and insurance. It will be a repeat. Sixth question. Yes, sixth.
Yeah.
Hello.
Yeah, it's a repeat.
So it's social security and insurance. Repeated 4 times, but I think it will pretty much the previous concepts will be repeated. So yeah. Okay. Social security is a vital form of statutory protection to secure a worker and their dependents from poverty and provide social security against contingencies of sickness, maternity, disability, employment injury, old age, and death. It is broadly based on principles of social justice and economic welfare to avert poverty and assist individuals to maintain a humane and dignified life. The concept of social security in India is a constitutional mandate in that each state has an obligation to provide a welfare state as incorporated in the directive principles of state policy, Articles 39, 41, and 43. 39, 41, 43 stipulates this, and each state is constitutionally obligated to do something about it. The statutory framework ఏముందంటే ఈ సోషల్ సెక్యూరిటీకి అన్ని చట్టాలు ఇక్కడ రాశారు. I'll go through it. ఇందాక చదివినట్టు ఎంప్లాయీ స్టేట్ ఇన్సూరెన్స్ యాక్ట్ 1948, precisely called the ESI Act, provides for integrated medical care, cash benefits in case of sickness, maternity, and employment injury. It is applicable to establishments employing 10 persons or more. The daily wage limit for coverage is 21,000 per month, and for disability it is 25,000. The contribution to fund comes from both employer and employee, 3.25% and 0.75% respectively. So employer is 3.25, employee is 0.75. Next Act statutory framework is the Employees Provident Funds and Miscellaneous Provisions Act 1952, EPF and MP Act. It covers retirement savings, which is Provident Fund, pension, EPS, and deposit linked insurance, EDLI. The employer and employee contribute 12% of basic wages to the fund. So, this fund ki the employer's employee contribute 12% of basic wages to the fund. అంటే ఇది నాకు అర్థం కాలేదు. ఐ హావ్ టు రీడ్ అప్. ఎంప్లాయీస్ కాంట్రిబ్యూట్ బేస్ 12% బేసిక్ అయినా 6% 6%, 50-50 కాంట్రిబ్యూట్ చేస్తారా?
No, 12% plus 12%.
Correct.
Really?
12%
Wow,
from
that's
employee salary, and similarly, if employer also contributes 12%.
But they remove it as
Okay.
cost of company. CTC and
Yes.
దాంట్లో యాడ్ చేస్తారు.
Yes, that's right.
Mhm.
Everything
Okay.
comes from salary only.
Gratuity Act 1972 is another statutory piece of legislation we have. Provides a lump sum benefit when employment is terminated. So terminated because of retirement, death, designation, disablement, when employed continuously for 5 years. Does not apply to death and disablement. What is this nonsense? Provides a lump sum benefit, the gratuity, when employment is terminated. A termination ఎప్పుడు అవ్వచ్చు? రిటైర్మెంట్, డెత్, రిజిగ్నేషన్, డిజేబుల్మెంట్ అని ఉంది. When employed continuously, 5 years employment ఉంటే continuous గా, then this will apply. Does not apply to death and disablement అని ఉంది మళ్ళీ parenthesis లో. What is it?
No, after 2 years, if somebody, after working for 2 years, if somebody dies and enter,
5
they
years.
need to calculate up to 58 years, madam. As if assume that he has worked up to 58 years. So they need to pay gratuity accordingly. Yeah, that's.
Oh, no, this 5 years limitation, 5 years పని చేయాలన్న లిమిటేషన్ డెత్ డిజేబుల్మెంట్ కేసెస్ లో అప్లై అవ్వవు కానీ మిగతా అన్ని కేసెస్ లో రిటైర్మెంట్ గానీ, రిజిగ్నేషన్ గానీ, డెత్ ఈ 5 years అప్లై అవుతుందని. ఓకే, గాట్ ఇట్.
Only for death it is assumed that he has worked up to his retirement age.
Yeah, okay.
అండ్ అందులో సీలింగ్ పెట్టేస్తారు.
21 and 25 కదా, అదేనా? That's what you're saying? No.
20 lakhs. Yeah.
20 lakhs, okay.
అది అక్కడ కూడా
So
ప్రింటెడ్ రాలేదు అనుకుంటా. కరెంట్ సీలింగ్ లిమిట్ 20 lakhs. We have to change that also. Yeah. Missing value from original text.
Original text. That's so cute when he says that. Missing value from original text. Okay. So anyway, Maternity Benefit Act 1961 is another statutory benefit we have, which is Maternity Benefit Act 1961, grants 26 weeks paid maternity leave, nursing breaks, safeguards against termination while on maternity leave, as well as enhancing protection of employment rights for women. So these are very critical provisions. Actually, 26 weeks paid maternity leave. This is also considered as a part of continuous employment. Then nursing breaks are allowed. Safeguards against termination while on maternity leave. You cannot terminate the person. As well as enhancing protection of employment rights for women. So this is Maternity Benefit Act. Code on Social Security 2020, a landmark consolidating statute that has brought together 9 existing social security laws, which are EPF, ESI, Gratuity, Maternity Benefit Act, etc., in order to increase and enhance coverage of social security to gig workers, platform workers, and workers in the unorganized sector, with a view to providing an all-round comprehensive and inclusive coverage. In Telangana, the Gig and Platform Workers Act is under serious consideration by the government, actually.
Okay.
Then what is the constitutional mandate? So these are the statutory framework, but there is also a mandate by the Constitution of India, which includes Article 39E, protecting workers against economic exploitation. Then 41, right to public assistance in case of unemployment, old age, sickness, and disablement. 43, directing the state to secure for workers a living wage and conditions of work ensuring a decent standard of life. So actually the directive principles of state policy talks about a living wage, which is an aspirational wage, but any increase in wage should be in the direction of reaching the living wage. Actually, direction lo vellali. These responsibilities require legislation towards the welfare of workers. So this is what it is. 39E, 41, 43 are the constitutional provisions. What is the objective of Social Security? Reducing poverty and economic insecurity, providing for healthcare and income protection in the event of contingency, improving workforce morale and maintaining industrial peace, in creating equity, fairness of treatment, and social justice in the labor market. So, fairness of treatment and social justice in the labor market. So, those are those. And what are the relevant case laws? There are a couple of case laws here. One is what we discussed earlier also, Regional Director ESIC versus Francis DeCosta. So they said right to life lo bhaganga undi ee social security and article 21 of the constitution. The court stated that employees eligibility of benefits of the ESI scheme depends on number 1 the duties, and 2 notwithstanding how the employer cap wages, the employer cannot ignore employees having the same duties because of job designation. The court stated that legislation, rules, and regulations governing the standards of welfare statute should always be construed in a beneficial manner, giving liberal interpretation. The next one is Kolkata Electric Supply Corporation Limited versus Subhash Chandra Bose, AIR 1992. So పైది అయితే వాడు సేమ్ టైప్ ఆఫ్ ఎంప్లాయ్మెంట్ కి సేమ్ ఇవ్వాలి అని చెప్పాడు. నెక్స్ట్ ది ఎంప్లాయ్ Supply Corporation, Electric Supply Corporation versus Subhash Chandra Bose. The Supreme Court held that gratuity is a statutory right arising from long and continuous service, not a discretion. So it is mandatory. The court rejected an appeal that gratuity could be withheld due to resignation, and particularly held that if the employer has options available to challenge employment termination, it does not mean that the employer can arbitrarily deny gratuity. Technicalities of procedure should not deny the substantive rights of a worker. Article 1972. So technical reasons, రకరకాల reasons చెప్పి one cannot escape the obligation of gratuity. The employer cannot అని clear గా చెప్పింది కోర్టు. So social security today, social security authority and relevance has become amplified by the gig economy and platform work. The Code on Social Security 2020 formally extends the coverage of this group of non-traditional workers. So these are app-based workers, kada, gig and platform workers. So this is the most recent development in the past like 5 years or so or 6 years. So the code of and encompasses them also. Control through unification can govern a worker's proximity, drive sustainability of the sector, facilitate, and they're justifying why this code has come into being, the consolidated code. Control through unification can govern a worker's proximity, drive sustainability of the sector, facilitate easy operation, enable the state to better comply, allow all workers the take-up of a specific benefit, and provide an overall safety net to the largest number of workers in India. Therefore, this consolidation, they are justifying. That is about the social security concept. So, next one is Whitley. Venu garu, your favorite Whitley commission has come. Read it and finish it for today.
So the last question, మీరు చదివింది మేడం, it is like a summary of all the 5 questions which we completed now.
Exactly. Correct.
Yeah.
Social security. Yes.
And ఇందులో ఈ కేసు కూడా ఉంది, which we repeated, Regional Director versus Francis DeCosta. ముందు కేసులో we were talking about another issue where we are notional extension. బేసికలీ ఈ కేసులో ఏంటంటే మేడం చాలా గైడ్ లైన్స్ ఇచ్చారు ESI లో ఎలా ఇవ్వాలి, ఏం చేయాలి అని. దట్స్ వై దిస్ కేస్ ఇస్ వెరీ ఇంపార్టెంట్.
So it can be quoted in multiple concepts kada.
Exactly. So in ESI we were talking about notional extension, like ఉద్యోగంకి వచ్చేటప్పుడు వాడు యాక్సిడెంట్ అయినప్పుడు whether it can be given or not, right? So ఇక్కడ సేమ్ జాబ్ డెసిగ్నేషన్ ఉన్న వాళ్ళకి you cannot have different క్యాప్ వేజెస్, డిఫరెంట్ బెనిఫిట్స్ ఉండటానికి వీల్లేదు అని చెప్తున్నారు కదా. సో బేసిక్లీ కేస్ ఈజ్ ఇంపార్టెంట్ బికాస్ ఈఎస్ఐ రిలేటెడ్ చాలా గైడ్ లైన్స్ ఇచ్చారు అనమాట ఈ కేసులో. రీజనల్ డైరెక్టర్ వర్సెస్ ఫ్రాన్సిస్ డికోస్టా.
ఓకే. ఎక్కడైనా ఫుల్ కేస్ రాసారా ఈ బుక్ లో? ఫుల్ కేస్ అంటే ఐ డిడ్ నాట్ మీన్ ఆల్ ద ఆర్గ్యుమెంట్స్ బట్ ద ఫుల్ జడ్జ్మెంట్.
నేను రాయలేదు మేడం, దీనికే 100-200 పేజీలు అయిపోతుందని తిడుతున్నారు కదా. సో
No, no, I'm
అందుకని
just thinking అంటే అన్ని ఒకసారి చదువుకుంటే ఎక్కడెక్కడ వాడొచ్చో తెలిసిపోతుంది కానీ ఎనీవే
కరెక్ట్
ఓకే.
అండ్ దే ఆల్సో గేవ్ ఎ లిబరల్ ఇంటర్ప్రిటేషన్ అనమాట టు అంటే ఇన్ ఇన్ ట్యూన్ విత్ ద వర్కర్స్.
It should always be on the side of the workers. Yeah.
Second case is also gratuity. Social security లో gratuity వస్తుంది, but this case can be quoted even in gratuity. This Calcutta, so ఇది చాలా స్ట్రాంగ్ గా చెప్పింది గ్రాట్యుటీ ఈజ్ అ రైట్ అని. సో అది నీ డిస్క్రిప్షన్ కాదు, నువ్వు ఇవ్వాలో లేదో, ఇట్ ఈస్ అ స్టాట్యుటరీ రైట్. సో దే హ్యావ్ టు గెట్ ఇట్.
Correct.
Okay, madam. We'll go to the next Whitley Commission. I think we have already studied that in the long questions, but we'll go repeat again. So basically the context of why Whitley Commission was formed is basically the context of wages before pre-independence in 1931. The Whitley Commission was set up. So it was essential to understand the prevailing conditions at that time. One was low wage levels. Indian industrial workers generally received extremely low wages, barely sufficient for subsistence. Okay. So although there was abundant labor supply but weak bargaining power of workers ఉండేది, which was largely unorganized, and wage disparities, significant disparities in wage ratios across different industries, regions, and even within same establishment of similar work. The lack of standardization led to exploitation and discontent. Unfair deduction and fines. So employees frequently imposed arbitrary fines and made unnecessary deductions from workers' wages for various reasons. A lack of regulation. There was no regulation mechanism to protect this workers' earnings. Market forces heavily tilted in favor of employers. So, and payment practices. Payment of wages was often irregular, sometimes made in kind or through intermediaries, leading to further exploitation. So against the backdrop, the Whitley Commission recommendation on wages aim to bring about more equitable and regulated system. One is detailed explanation of key recommendations of wages. So what did they recommend? One is standardization of wages. The rationale which they gave is the Commission recognized the wide variation in wage rates for similar work were major source of grievance and injustice. So అందుకని they standardize the wages that would bring fairness, reduce exploitation, promote industrial harmony. Second one was recommendations. They strongly advocated for establishment of standard wage rates for different occupants within industries and across multiple regions. This would involve classifying job based on skill, effort, and responsibility, and then setting uniform wage scales for each category. And implementation, the Commission suggested the standardization process should be based on systematic inquiries into prevailing wage rates, nature of work, cost of living in different areas. They emphasized the need for government intervention, potentially through wage boards, to facilitate this process of organized industries. So, second one is first standardization of wages. So second is machinery for fixing minimum wages. So what is the rationale for how do you come to minimum wages? The Commission particularly concerned about the plight of workers in poorly organized industries who lack bargaining power. It is recognizing the market forces alone would not guarantee a minimum decent standard of living for these workers. So recommendation into they recommended the creation of statutory machinery for fixing minimum wages in the industries where labor were unorganized. This machinery would take up the form of wage boards, comprised of employer, employees, and the independent members empowered to investigate wage levels and set minimum rates. Scope into the Commission envisioned the minimum fix machinery being applied selectively to industries and regions where it is most needed. The third one is principle of fair wages. So what is the rationale? The Commission went beyond the mere subsistence wage and introduced the idea of fair wage. So the idea of fair wage first ఇక్కడ వచ్చింది, ఆ తర్వాతే వేరే కేసెస్లో వచ్చింది. They recognize that the workers were entitled to more than just bare necessities of life, and then the wages should reflect factors beyond the absolute minimum requirement for survival. So how do you calculate the fair wage? Defined fair wage as lying between minimum wage and living wage. The actual determination of fair wage is given by industry would depend on several factors. One is productivity, prevailing rate of wages, level of national income distribution, capacity of industry to pay. So in that we talked about all these. And the significance is the concept of fair wage provided a framework for progressive wage determination, moving beyond survival. So, and then the fourth one is prevention and unfair deductions. The commission found that arbitrary fines and deductions from wages were rampant and significantly reduced workers' mere earning. This practice often lacked transparency and due process. So, recommendation ఏంటంటే registration to regulate deduction from wages. The legislation should clearly specify the grounds for deduction, maximum amount that could be deducted, and the procedures to be followed. Impact and these recommendations directly led to the enactment of laws called the Payment of Wages Act 1936, which aimed to prevent unauthorized deductions and ensure payment of wages with undue cuts. Fifth one is wage incentives. The commission recognized the potential of wage incentives to create increased productivity. However, they were aware of risk of exploitation associated with poorly designed and unfairly incentive systems. Recommendations, they suggested what incentives were introduced, they should be based on clear and understandable principle. Benefits of increasing productivity should be fairly shared between employees and employees. So impact and legacy of Whitley Commission ఏంటంటే 2 acts వచ్చాయి. ఒకటి Payment of Wages Act 1936, directly addressing the commission's concerns about unfair deductions. The second one is Minimum Wages Act 1948, directly implementing the commission's recommendations for establishing machinery for fixed minimum wages in certain industries. ఓకే, సో 1930లో ఈ ఇండియన్ ఎకానమీ ఇష్యూ ప్రాబ్లమ్స్ ఉన్నప్పుడు 1931లో విట్లీ కమిషన్ వేశారు. 1936కి ద ఫస్ట్ యాక్ట్ వాజ్ ఇంట్రడ్యూస్, ద పేమెంట్ ఆఫ్ వేజెస్ యాక్ట్ వాజ్